An Introduction to Constitutional Law, 100 plus Supreme Court Cases Everyone Should Know by Randy Barnett and Josh Blackman.
What is it taking? Pennsylvania Coal Company versus Mahon, 1922, and Penn Central Transportation Corporation versus New York, 1978. The Fifth Amendment ends with the following clause: nor shall private property be taken for public use without just compensation. In Barron versus Baltimore, 1833, the Supreme Court held that the Takings Clause restricted the federal government. The first 8 amendments, now known as the Bill of Rights, did not limit state action. This dynamic would change following the ratification of the 14th Amendment. In Chicago, Burlington and Quincy Railroad Company versus City of Chicago, 1897, the Supreme Court held that the state violates the Due Process Clause of the 14th Amendment when it takes property for public use without providing just compensation. However, the opinion never cited the Fifth Amendment. Yet, under modern doctrine, the Takings Clause has been deemed incorporated to the states like the other provisions of the Bill of Rights. The 12 words of the Takings Clause raise 4 distinct legal questions. First, what is property? Second, what is a taking? Third, what is a public use? Fourth, what is just compensation? This unit will focus on the second and third questions. When the state takes private property, it must provide just compensation. However, when the state regulates property under the police power, the government does not need to provide just compensation. How do we distinguish between a taking, which requires just compensation, and an exercise of the police power, which does not? In some cases, it is fairly obvious when the government takes your property. For example, in Kelo v. City of New London, the government exercises power of eminent domain to quite literally take Suzette Kelo's home. Here, there is no question that there was a physical taking for purposes of the Fifth Amendment. However, what happens when a governmental regulation limits how a property can be used and therefore reduces its value? Does such an action amount to a regulatory taking because it reduced the value of the property? Or is the state merely exercising its police power? The answer is complicated because the Supreme Court has not provided a consistent definition of a taking. Our first case, Pennsylvania Coal Company versus Mahon, 1922, offered an early attempt to draw a line between a regulatory taking and the police power. In 1921, Pennsylvania enacted the Kohler Act, which forbade the mining of anthracite coal in such way as to cause the subsidence of, among other things, any structure used as a human habitation. Sometimes when coal is mined below ground, a structure above ground may sink. This process is known as subsidence. In our case, Mahon owned the surface rights. The Pennsylvania Coal Company had acquired the subsurface right to mine coal prior to 1921. Mahon sued the coal company for violating the Kohler Act. In response, the coal company asserted that the Kohler Act was an unconstitutional taking that did not provide just compensation. The Supreme Court agreed by an 8-1 vote. Justice Holmes wrote the majority opinion. Study guide. In Mahon, Justice Holmes found that the 14th Amendment empowered the courts to carefully scrutinize takings of private property. How does Justice Holmes interpret the 14th Amendment in Lochner v. New York, 1905? He acknowledged that the, quote, government hardly could go on if, to some extent, values incident to property cannot be diminished without paying for every such change in the general law. However, he wrote, the police power is limited. When the, quote, extent of the diminution in value is too great, there, quote, must be an exercise of eminent domain and compensation to sustain the act. Justice Holmes found that the Kohler Act, quote, is not justified as protection of personal safety. Moreover, the, quote, extent of the taking is great. Holmes wrote that, quote, the statute does not disclose a public interest sufficient to warrant so extensive a destruction of the defendant's constitutionally protected rights. Therefore, quote, the act cannot be sustained as an exercise of the police power so far as it affects the mining of coal under streets or cities and places where the right to mine such coal has been reserved. What is the test? Quote, the general rule, at least, is that while property may be regulated to a certain extent, if the regulation goes too far, it will be recognized as a taking. This test is not very helpful. Study guide. Is the regulatory takings doctrine articulated in Mahon consistent with the original meaning of the Constitution? Is the government required to provide compensation where an owner keeps his property, albeit with a reduced value? Justice Brandeis was a lone dissenter. He wrote that the legislature has the police power to prohibit such uses without paying compensation. For a restriction imposed to protect the public health, safety, or morals from dangers threatened is not a taking. Justice Brandeis offered a different test. The court should not limit its consideration only to the small parcel of land on which the coal company can no longer mine. Rather, the court should consider the value of the whole property on which the coal company can still mine. This test would become known as the parcel as a whole test. The Supreme Court would embrace Justice Brandeis' dissent 5 decades later. The Penn Central Transportation Corporation wanted to build a tower atop Grand Central Terminal in Manhattan. However, New York City designated the train station as a landmark and blocked the construction of the tower. Penn Central argued that the designation was an unconstitutional taking of its air rights. The Supreme Court upheld the designation in Penn Central Transportation Corporation versus New York, 1978. Justice Brennan wrote the majority opinion. Even though New York's law diminished the value of the air rights, Penn Central could still benefit from other portions of Grand Central Terminal. Therefore, there was no taking. In other words, because the court considered the parcel as a whole, the diminution in value did not go too far.